Madam Speaker, I rise to lead the debate of and have read for a second time in this Honourable House the bill shortly titled Nevis Island Administration Civil Proceedings Bill 2023. Madam Speaker, the bill is short and simple. It is but one page on both sides, printed on both sides. However, Madam Speaker, it is an important bill as it was drafted as a collaborative effort between the Attorney General's Office and the Legal Department of the Premier's Office. Madam Speaker, despite its brevity, it is acutely and constitutionally important and involves the interaction of the three fundamental elements within our separation of powers configuration of government. The bill, Madam Speaker, seeks to fill a legislative gap identified in a judgment written by the Chief Justice of the Eastern Caribbean Supreme Court, Dame Janice Pereira, in a court case styled Nevis Island Administration versus Ocean Reef Resorts Limited. Madam Speaker, in effect, the judicial arm of government has adjudged that the executive arm of government has a limitation, which wasn't and therefore must be rectified by the legislative arm of government. This debate, therefore, Madam Speaker, is a perfect lesson for our people in the fundamentals of government and how the three branches of government can affect each other in a practical way. The bill, Madam Speaker, is also a precursor to the holistic constitutional enhancement exercise which the federal government and the Nevis Island Administration are about to embark on to tailor a robust constitution to guide our proud federation for another 40 years. The reason for the bill, Madam Speaker, is that in the NIA versus Ocean Reef Resorts Limited court case I referenced, Chief Justice Pereira issued a judgment which concluded that, and I quote, "The NIA has no legal standing to sue and be sued in civil proceedings, given the applicability of the Crown Proceedings Act to Nevis, and further, that the proper party to Ocean Reef's claim and the proper party to be served in respect of the claim is the Attorney General of St. Kitts and Nevis," end quote. Note, Madam Speaker, that the federal government was in no way involved in the dispute between the NIA and Ocean Reef. However, the Chief Justice ruled that the federal parliament had no intention for the NIA to be clothed with legal standing to sue or be sued in civil proceedings. And that, I quote, "The NIA is therefore part and parcel of the Crown for the purpose of the Crown Proceedings Act." Madam Speaker, this bill therefore seeks to directly fill the legal gap identified by the learned Chief Justice. Nothing more, nothing less. With your leave, Madam Speaker, I wish to read the three main provisions in the bill, which state, subject to Section 37(6), Chapter 10, and Schedule 5 of the Constitution, the Nevis Island Administration shall have the power to sue and be sued in its own name. All documents required to be served on the Nevis Island Administration for the purpose of or in connection with any civil proceedings against the Nevis Island Administration shall be served on the legal department of the Office of the Premier of the Nevis Island Administration. And lastly, all documents required to be served on an officer of the Nevis Island Administration, as distinct from the Nevis Island Administration itself, shall be served personally on that officer. As I said, Madam Speaker, this is a simple bill, but important and impactful. Since the judgment by the learned Chief Justice, lawsuits against the NIA have been served on the Attorney General's chambers in Bastia. We have been issuing fiats which are effectively formal orders of permission for NIA's legal department to take carriage of defending those lawsuits. For the benefit of the general public, I think it's important to address the constitutional and historical background which gave rise to this gap that the National Assembly is seeking to fill. Our independence constitution, which took effect on September 19, 1983, is the supreme law of St. Kitts and Nevis. And if any law is inconsistent with the Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. The Crown Proceedings Act became law in June 1956 and was significantly amended in 1976. It is an act that provides for matters relating to the civil liabilities and rights of the Crown, and to provide for matters relating to civil proceedings by and against the Crown, etc. Civil proceedings are effectively legal disputes filed in court that are not criminal in nature. The key provisions of the Crown Proceedings Act state that civil proceedings against the Crown shall be instituted against the Attorney General, and all documents required to be served on the Crown for the purpose of or in connection with any civil proceedings by or against the Crown shall, where the proceedings by or against the Crown are brought in the name of an officer of the Crown, other than the Attorney General, be served on that officer or on the Attorney General. That is how the structure was since 1956. Historically, the Crown, otherwise known as the state, was Nevis and St. Kitts together. Pre-independence, Nevis did not have any legal status separate from the single state of both islands. Nevis relied on the only government, headquartered in Bastia. It is for this reason the crafters of the Constitution, within the political landscape of the day, sought to create a legal structure so that Nevis had some autonomy over its own affairs. The Constitution therefore created the Nevis Island Administration. It is firmly a legal creature with judicial standing sanctioned by the highest law of this land. However, without specific provisions in the Constitution that allow the NIA to sue and be sued, and the Crown Proceedings Act being drafted at a time when there was a singular state made up of three islands at that time, there was room for an interpretation that there was no legal permission for the NIA to sue and be sued separate from the single state. The bill tabled today seeks to plug that gap. Of note, Madam Speaker, if you will allow me to diverge a bit to inform our people that we are not alone in this world in the styling of our two-island federation structure. There is a similar, yet not identical, structure in Africa. The United Republic of Tanzania, made up of mainland Tanzania and the group of islands known as Zanzibar, is a unitary state based on a multi-party parliamentary democracy. All matters of state in the United Republic of Tanzania are exercised and controlled by the government of the United Republic of Tanzania and the revolutionary government of Zanzibar. Federal government of St. Kitts and Nevis, United Republic of Tanzania, Nevis Island Administration, revolutionary government of Zanzibar. The government of the United Republic of Tanzania has authority over all union matters in the United Republic as stipulated under their constitution. And it also runs all non-union matters on mainland Tanzania, the territory formerly known as Tanganyika. I hope I'm not slaughtering that name. The revolutionary government, equivalent to the NIA, administers everything else. For clarity, Madam Speaker, the union matters in their constitution are the constitution itself, foreign affairs, defense and security, police, emergency powers, citizenship, immigration. Sounds familiar, Madam Speaker? service in the government of the United Republic, income tax payable by individuals and by corporations, customs duty, excise duty on goods manufactured in Tanzania, collected by the Customs Department, harbors, matters relating to air transport, ports, telecommunications, matters concerning coinage and currency for the purposes of legal tender, banks, banking business, foreign exchange and exchange control, industrial licensing and statistics, higher education, mineral oil resources, including crude oil, National Examinations Council, civil aviation research, meteorology, statistics, the Court of Appeal of the United Republic, and registration of political parties and other matters related to political parties. That is the federal responsibilities of that state. Everything else is dealt by the equivalent of the NIA. Madam Speaker, in St. Kitts and Nevis, Section 106(1) of the Constitution states that the NIA shall have exclusive responsibility for the administration within the island of Nevis in accordance with the provisions of any relevant laws of the following matters: airports and seaports, education, extraction and processing of minerals, fisheries, health and welfare, labor, land and buildings vested in the Crown and specifically appropriated to the use of the government, licensing of imports and exports out of St. Christopher and Nevis. I sense that the Premier's brain is working, thinking about the impending constitutional negotiations for there to be potentially a federalist, and Nevis gets to control everything else, like in Tanzania. Honorable Premier, please note that the Constitution of that nation states, the government of the United Republic shall maintain a special account to be known as the Joint Finance Account, and which shall form part of the Consolidated Fund of the United Republic, into which shall be paid all the monies contributed by the two governments in such proportions as shall be determined by the Joint Finance Commission in accordance with a law enacted by Parliament for the purposes of the business of the United Republic in relation to union matters. That is how they dealt with their share of revenue. There, and I quote, continue to quote, there is hereby established a Joint Finance Commission consisting of not more than 7 members who shall be appointed by the President in accordance with this article and the provisions of a law enacted by Parliament. The functions of the Commission shall be to analyze the revenue and expenditure arising from or relating to the management of affairs concerning union matters, and to make recommendations to the two governments concerning the contribution by and the allocation to each of the governments. To keep under constant scrutiny the fiscal system of the United Republic and also the relations between the two governments in relation to financial matters. To discharge other functions which the President shall assign to the Commission, or as the President may direct in accordance with the law enacted by Parliament. Isn't that an interesting system, Madam Speaker? Madam Speaker, I say all of that to say that when the Joint Constitutional Review Committee that is being set up by the Prime Minister is expanded and moves to the next phase of holistic reform of our Constitution, we won't have to reinvent the wheel. There are international and regional examples we can examine to create the best bespoke constitutional solutions in the best interests of the people of St. Kitts and Nevis and our body politic. With respect to the reasons for the bill, Madam Speaker, it is arguable that the framers of our Constitution, when allocating matters within the exclusive domain of the NIA, simply forgot to expressly include the NIA's ability to sue and be sued. It is similarly arguable that that right didn't need to be expressed in writing, but it was inherently understood that the Crown Proceedings Act would be read subject to the Constitution, the NIA being an express arm of the Crown in the Constitution. On whichever side of that argument one falls, it's our duty as legislators to find the solution. We firmly believe that the Nevis Island Administration Civil Proceedings Bill 2023 is that solution, and we humbly wish its safe passage and the support of the entire National Assembly, but at least 2/3 of the elected members of this august body. The reason I said 2/3, Madam Speaker, is because Section 37(6) of the Constitution which provides that Parliament may make additions to the matters specified in Section 106(1). But the bill for that purpose shall not be regarded as being passed in the National Assembly unless, on its final reading, it is supported by the votes of not less than 2/3 of all of the representatives. Whilst granting the NIA the ability to sue and be sued seems an inherent status of a constitutionally established entity, out of an abundance of caution, and to avoid any potential legal challenges which could arise in this litigious society of ours, the Attorney General's Office and the Legal Department of the NIA felt it necessary to ensure that this bill receives a 2/3 majority, contemplated by Section 37(6). That means the support of at least 8 of the 11 elected members. Madam Speaker, as I said when I started, it is a very simple, very short and simple bill, but very important. And with those few words and explanations for the bill, Madam Speaker, with your leave, I'd like to take my seat.